हेलो प्रोविंस। तो कंटिन्यूइंग हमारा रेजोल्यूशन ऑफ कॉर्पोरेट डिस्प्यूट्स का क्विक रिवीजन। तो यहीं पे थे लास्ट टाइम। सभी के रिवीजन के हिसाब से एडजुडिकेटिंग पेनल्टीज क्या रहती है, तो याद रखना सेक्शन 59 टॉक अबाउट एडजुडिकेटिंग पेनल्टी। इसके हिसाब से सभी एडजुडिकेटिंग पेनल्टी ऑफिसर हैज टू डिटरमाइन द पेनल्टी एज पर 15A to 15H। अब एडजुडिकेटिंग ऑफिसर अगर पेनल्टी डिटरमाइन करेगा तो कंडक्ट क्या करेगा, इंक्वायरी। तो ही हैज टू कंडक्ट द इंक्वायरी। फॉर दैट ही इश्यूज समन्स। समन्स के साथ साथ ही विल कलेक्ट द एविडेंसेस एंड अपने आप में सेटिस्फाई करेगा इधर टू रिलीज अ पार्टी और टू इम्पोज अ पेनल्टी। ओके, नाउ अगर एडजुडिकेटिंग ऑफिसर सबमिट्स द रिपोर्ट टू सेबी तो क्या आउटकम होगा? वेल, इसके अंदर सेबी एग्रीज विद द रिपोर्ट दैट ऑफ द एडजुडिकेटिंग ऑफिसर। So in 3 months of the order, SEBI conducts a personal hearing. And if not accepting the report of the adjudicating officer, then SEBI may issue notices for rehearing and granting the opportunity of being heard and conducting the inquiry as it deems fit. Well, इस केस के अंदर याद रखना फिर इसके साथ साथ कि in the interest of the security market, SEBI can impose penalty or enhance the penalty also. 15J के हिसाब से क्या क्या चीजें याद रखना? 15J के हिसाब से याद रखना फैक्टर्स टू बी कंसिडर्ड फॉर इम्पोजिंग पेनल्टी। तीन मेन इंपॉर्टेंट फैक्टर्स कौन से थे? वेल, द अमाउंट ऑफ डिसप्रोपोर्शनेट गेन और अनफेयर एडवांटेज is quantifiable as a result of the default. Second, the amount of loss which is caused to the investor as a result of default. And third, the repeated nature of default. So amount of loss and the repeated nature. 15J के हिसाब से क्या क्या याद रखना? 15J के हिसाब से याद रखना the person paying the penalty has to pay to the SEBI and it will be going to the Consolidated Fund of India. Okay, बाकी JB 24 और 24A as usual पेज 180 के ऊपर आप देख सकते हो. So page 180 of the module will talk about this. Okay. Here it is. So page 180 पे आप ये sections देख सकते हो. 15JB, 24 and 28A. So here it is. This is the recovery of amounts 28A. Okay, and 15JB इधर था, ये रहा सेटलमेंट एडमिनिस्ट्रेटिव प्रोसीडिंग्स एंड इसके साथ साथ सेक्शन 24 व्हाट आर दी ऑफेंसेस। ठीक है, तो ये यहाँ से आप पढ़ के आराम से जा सकते हो। अब इसके साथ साथ दूसरी चीजें जो आपको देखनी है, कंटिन्यूइंग दिस फैक्टर्स अगेन, पेनल्टीज ऑफ सिक्योरिटी कॉन्ट्रैक्ट रेगुलेशन एक्ट। तो सेक्शन 23 क्या बोलता है? तो सिक्योरिटी कॉन्ट्रैक्ट रेगुलेशन आया, पेनल्टीज आई, उसके अंदर ऐसे पढ़ने में बहुत सारे पेनल्टीज है, प्लीज पढ़ के जरूर जाना। तो सेक्शन 23 बोलता है इफ देयर इज अ पर्सन एंड ही फेल्स टू कंप्लाई विद द सिक्योरिटी कॉन्ट्रैक्ट रेगुलेशन एक्ट और ही फेल्स टू एंटर इनटू एनी काइंड ऑफ कॉन्ट्रैक्ट, चाहे फिर वो डेरिवेटिव मार्केट में हो या स्टॉक एक्सचेंज के रेगुलेटरी रिक्वायरमेंट्स के हिसाब से, एंड ही स्टार्ट डीलिंग इन द कॉन्ट्रैक्ट and he is not even a member in the security or not even an intermediary, so there is a violation of the regulation. Okay, so that's where it is, section 23 comes into picture. So there is a violation of the regulation, that a person who fails to comply with the contract and there is a violation of regulation, penalty can be going up to 10 years or 25 years. 23A क्या बोलता है? पेनल्टी टू फेल टू गिव इंफॉर्मेशन। 23A, तो 23A talks about this, that penalty for failure to give information minimum 1 lakh and this much per day. Okay, 23B किसके बारे में बात करता है? 23B का मतलब होता है if there is a failure of any person to enter into any kind of agreement with the clients, so that is penalizable. Then 23C किसके बारे में बात करता है? Penalty for failure to redress the grievance of the investors. Okay, उसमें minimum 1 लाख से लेके 1 करोड़ तक की penalty रहती है. 23D talks about penalty for failure to segregate the securities or monies of the client. 23E talks about penalty for failure to comply with the provision of listing agreements, तो उसमें penalty आ सकती है. 23F penalty for excess dematerialization you can say of delivery of the securities, तो इस केस में भी 5 लाख से 25 लाख तक की पेनल्टी आ सकती है. इन सबको अच्छे से एक बार रीड करके जाना, तो यू हैव अ प्रॉपर आइडिया एटलीस्ट. ओके, एंड उसके साथ साथ 23G टॉक्स अबाउट पीरियोडिकल रिटर्न्स टाइम पे सबमिट नहीं करना. So when you don't study, give your periodical returns on time. Okay, बाकी study के हिसाब से just remember them. I'm not asking you to by heart them. Please remember them. That will be sufficient. And penalty for the failure to conduct the business in accordance with the rules, उसके ऊपर भी penalty हो सकती है. And 23X penalty for contravention when no separate penalty is provided. ओके, बाकी ये सेक्शंस काफी हद तक सेम ही थे। 23I 15I के जैसा, 23J 15J के जैसा, 23JA 15JB के जैसा, 23JB 28A के जैसा है, तो ये एकदम सेम ही थे। अब आता हूँ SCRA के 23JC के हिसाब से। तो JC किस लिए फेमस था? कोई भी पर्सन who gets into an estate, assets, money of any of the deceased and he has right to represent that deceased is called a legal representative, बराबर। अब अगर लीगल रिप्रेजेंटेटिव है तो सीधी बात है उससे रिकवरी होगी। तो रिकवरी ऑफिसर ही कैन रिकवर द पेनल्टी फ्रॉम द लीगल रिप्रेजेंटेटिव, ही कैन डायरेक्ट द लीगल रिप्रेजेंटेटिव टू रिफंड द मनी ऑफ द इन्वेस्टर्स, he can recover the disgorgement amount from the legal representative. अच्छा, disgorgement amount क्या होता है? Any kind of illegal profits which is attached to the transaction is the disgorgement amount. He can, and there can be penalty which is imposed upon the death of the person, and he can initiate the proceedings against such legal representative for recovery. Okay. What is the liability in this case? Well, legal representative is personally liable for any of such amount. And if the legal representative creates any charge on the deceased assets or he tries to sell the assets, okay, then any amount that comes into his possession later, the liability only is to the value of the assets of that. ठीक है। अच्छा, इसके बाद क्या आता है? वेल 23K आता है। 23K talks about penalties to be deposited in the consolidated funds of India. 23L क्या बोलता है? Well, 23L बोलता है person who is aggrieved by the order of SEBI or any kind of stock exchange. That person can file an appeal in 45 days, provided sufficient cause हो, so SAT can entertain the appeal thereafter also. After hearing the appeal, SAT can pass the order. Three types of orders याद रखना: confirm the orders of SEBI or SAT, modify the orders of SEBI or stock exchange, and set aside the orders. And SAT will give a copy of the order and dispose of the appeals. So that was 23L. Well, 23M, NO, and 24. These are simple terms that you can read from the module itself. Okay. Then about, yes, procedures for inquiry and imposition of penalties. इसमें क्या क्या चीजें याद रखना? Well, प्रोसीजर के हिसाब से सेबी होता है। सेबी क्या करता है? अपॉइंट करता है एडजुडिकेटिंग ऑफिसर को। एडजुडिकेटिंग ऑफिसर क्या करेगा? एडजुडिकेटिंग ऑफिसर करेगा कंडक्ट इंक्वायरी from the records which is available, and he will issue show cause notice to seek the reply to the contravention, and he will considers the reply of the offenders. He fixes the date of hearing, सामने वाला appear होगा. In the hearing he will give an opportunity of being heard. So yes, SEBI fixes, conducts inquiry, considers the reply of the offenders, and in the hearing he fixes an opportunity of the, and if required, adjournments to the future days can be made. In the inquiry, the officer can summon the person for enforcing the attendance, produce the documents. If the person fails or neglects by any reason, or if he does not produce any kind of document, so then SEBI can conduct the inquiry there too. If SEBI is satisfied that the person is liable, they can impose a penalty also. ओके, सो वो पार्ट भी देख लो। इंक्वायरी होता है, हियरिंग होती है, और उसके साथ साथ हाँ, ही कैन समन द एनफोर्स, एंड इफ एनी पर्सन फेल्स एंड नेग्लेक्ट्स, इफ satisfied that the person has been made liable, then he can impose a penalty also. Okay, and if there is any kind of error or mistake by the officer, then SEBI can rectify the order and the copy will be served upon everyone. So yeah, that's the order. Yeah, the order must state the reasons, and if there are errors, the copy will be served on everyone. Exactly. Yes. Now coming to कॉफी पौजा। कॉफी पौजा एक इंपॉर्टेंट एक्ट है, कई बार क्वेश्चंस आए भी हुए हैं। तो कॉफी पौजा के अंदर क्या क्या चीजें याद रखना है? आर्टिकल 22 के हिसाब से प्रिवेंटिव डिटेंशन का मतलब क्या होता है? दैट इज प्रोटेक्शन अगेंस्ट अरेस्ट इन केस ऑफ, वेल आर्टिकल 22 के हिसाब से फर्स्ट पॉइंट ये होता है कि कोई भी पर्सन कैन नॉट बी डिटेन without being informed the ground of arrest, and not that person cannot be detained unless he is given a right to consult a legal advocate. So यहाँ पे every detention has to be as per the requirement of Article 22. दूसरी बात याद रखना कि every person who has been arrested or detained in the custody, they will produce before the magistrate within 24 hours, excluding the time which is taken for the journey. And no person shall be detained in the custody without the authority of the magistrate concerned. बराबर? Okay? So no person to be detained in the custody without the authority of the magistrate. तीसरी बात याद रखना कि this provision will not apply for the time being for any alien enemies and to the person who has been detained under any kind of law which is there for preventive detention. So इस चीज का ध्यान रखना. Yes. So nothing stated above shall apply to the alien enemy or any person detained in that. And कोई भी लॉ प्रिवेंटिव डिटेंशन का shall not authorize a detention beyond 3 months. अगर ऐसा करना है तो एडवाइजरी बोर्ड का अप्रूवल चाहिए. एडवाइजरी बोर्ड क्या होते हैं? इट इज द बोर्ड विच इज कंसल्टिंग ऑफ अ हाई कोर्ट जज who is a reputed person and persons who is appointed by the government in this case. कि अगर भी किसी भी पर्सन को 3 months के ऊपर डिटेन करना है विदाउट पुटिंग एनी काइंड ऑफ चार्ज शीट, विदाउट पुटिंग एनी काइंड ऑफ चार्जेस अगेंस्ट दैट पर्सन, तो इन दैट केस एडवाइजरी बोर्ड शुड बी सफिशिएंट कि इसका डिटेंशन नेसेसरी है. That's what Article 22 talks about. So no person earn preventive detention for 3 months. The advisory board consisting of the person who have been appointed as a judge and reported before 3 months for that. See? And agar koi, where a person has been detained in pursuance of any kind of order which is passed in law for preventive detention. तो जो भी अथॉरिटी ऑर्डर बना रही है वो कम्युनिकेट करेगी अपना ग्राउंड्स के हमने उसको क्यों डिटेन किया, एंड अर्लीस्ट अपॉर्चुनिटी ऑफ बीइंग हर्ड विल बी गिवन टू दैट पर्सन. So that is covered in the fifth point where the person has been detained pursuant to any kind of order. Okay, and nothing stated in this clause while will require the authority to making such order to जो भी ऊपर का आपने पढ़ा, अथॉरिटी चाहे तो डिटेंशन ऑर्डर ऊपर और भी ऊपर पास कर सकती है इफ दे हैव सफिशिएंट ग्राउंड्स प्रोवाइडेड इट इज इन द पब्लिक इंटरेस्ट. जैसे कई बार टेररिस्ट लोगों का डिटेंशन होता है, तो इस चीज के लिए याद रखना. ठीक है, अब सेक्शन 3 की बात करते हैं. पावर्स टू मेक द ऑर्डर्स फॉर डिटेनिंग अ सर्टेन पर्सन. पावर टू मेक द ऑर्डर्स. हु कैन मेक सच ऑर्डर्स? द सेंट्रल गवर्नमेंट, जॉइंट सेक्रेटरी और स्टेट सेक्रेटरी कैन मेक द ऑर्डर्स. Okay, what orders can be passed? That any person, including the foreigners, to be prevented in any manner which is augmenting the details. So these kind of orders can be passed in this case. Orders can be passed for what purposes? The orders can be passed for these of the purposes. That is smuggling, abetting, promoting any kind of smuggling of goods, transporting of smuggled goods, harboring of smuggled goods. It is necessary to pass such kind of orders. Now, what CG, that is what state government details the order. State government is authorized to appoint any of the officer to detain such person. अच्छा, communication of the order, Article 22 के हिसाब से the person has to be communicate the order within 5 days and in exception circumstances 50 days के हिसाब से. ठीक है. Then execution of detention. Well, detention order होगा that may be executed by any place, any player in India in any manner as required by CRPC. Then advisory board. Yes, advisory board के बारे में याद रखना. Advisory board means a board which is constituted under Article 22. यही part ऊपर देखा था. Advisory board consists of a chairperson and 2 members. In 5 weeks from the date of detention, the person detained has to be produced before the advisory board. Advisory board will consider the references, the material which is placed upon it, the information which is provided to it, and in that case, the detained person will be you can say have a word with, and then they will prepare a report with the grounds and the paragraphs that whether the detention has to be continued, and if there are sufficient grounds to continue the detention, they will submit the report within 11 weeks of detention. That's what advisory board is all about. Okay, remember this thing. And yeah, there can be difference of opinion between the advisory board judges also. So if there is a difference of opinion, then majority will prevail, and the person who has detained will not be entitled to appoint any kind of legal practitioner. But based on the advisory board report, the government will make a decision whether to continue with the detention or not. Okay, so that's what you remember about advisory boards. Okay, section 9 you don't have to read it, it's more laws inoperative. Section 5 के बारे में बात करें तो section 5 बोलता है, first thing that the person जिसका detention हुआ है, that person has to be kept in the place and under such conditions as decided by the government concerned. And that person can be moved from one place to another within the state or from one state to another also. And if the detained person is moved from one state to another, then the consent of the other state has to be taken. Okay, so that is section 5 के हिसाब से. That is section 5 के हिसाब से. Then section 5A, exactly. Section 5A क्या बोलता है? Well, 5A बोलता है कि if the order of detention has been passed on any of the grounds, and maybe more than one ground especially, then each of such order has to be deemed to be a separately made. And such orders shall not be deemed to be invalid or inoperative merely on the ground that it is vague, inconsistent, irrelevant, or not connected to any person or invalid. Okay, so that is section 5A. Then section 5A के साथ साथ सेक्शन 6 क्या बोलता है? वेल, सेक्शन 6 के लिए आप ये याद रखना, सेक्शन 6 के लिए क्या बोलता है? सेक्शन 6 के लिए याद रखना, that is detention order shall not be invalid or inoperative merely because that the person has been detained and outside the territorial limits of the government or any of the officer concerned, and the place of detention is outside the limit. Just because किसी को बाहर जाके पकड़ा, that doesn't mean he is illegal. Then section 7 के हिसाब से क्या क्या याद रखना? Well, section 7 के हिसाब से याद रखना, if the government has reason to believe that जिसका भी हमने detention किया है, that person was trying to absconding or concealing himself, then the government can order cannot, and the government is not able to order execution of the order, then the government will submit a report to the magistrate or the metropolitan concern having the jurisdiction in this regard that they will execute the order as per the CRPC provisions. And it will be published in the official gazette. And if the person who has tried to abscond, his name and details will be given. And it has to be complied by the government wherever it is published. And every offense in this case will be a cognizable offense. Okay? So that is section 7 के बारे में. तो याद रखना सेक्शन 7 के बारे में ये सब चीज़ें. देन सेक्शन 10 के बारे में 10 के बारे में क्या याद रखना. देखो, द मैक्सिमम पीरियड फॉर एनी पर्सन कैन बी डिटेन अंडर द डिटेंशन ऑर्डर कैन बी एक्सपैंडिंग टू 1 ईयर. तो 3 मंथ्स तो है, लेकिन 1 साल से ज़्यादा नहीं, बिना किसी एनी रीजंस के हिसाब से. तो आपको रीजंस असाइन करना कंपलसरी है. ओके. देन इसके साथ साथ या सेक्शन 11 याद रखना, रिवोकेशन ऑफ डिटेंशन ऑर्डर. अगर स्टेट लेवल का ऑर्डर होगा, डिटेंशन ऑर्डर इज पास बाय द स्टेट लेवल, देन द रिवोकेशन कैन बी डिजाइन गिवन बाय द स्टेट लेवल. इफ सेंट्रल लेवल का ऑर्डर है, द डिटेंशन ऑर्डर इज पास बाय द ऑफिस ऑफ द सेंट्रल गवर्नमेंट, then the detention order is passed by the central government. Revoke can be given by the central government. State government can give a revocation with the permission of the central government. But revocation is not a kind of stoppage against any person. कि उसके खिलाफ कोई केस नहीं कर सकते, नहीं, ऐसा नहीं. You can start a case, you can file the case, you can continue the case against any of the person on any of the grounds stated therewith. Okay, so ये था revocation के बारे में. सेक्शन 12 के बारे में क्या याद रखना. सेक्शन 12 के बारे में याद रखना दो बातें. वेल, सेक्शन 12 में पहली बात यह है कि सेंट्रल गवर्नमेंट में रिलीज एनी ऑफ द डिटेन्ड पर्सन इफ स्पेसिफाइड पीरियड विदाउट विद द कंडीशन इज देयर, ही इज एक्सेप्टेड बाय सच पर्सन दैट उसने कुछ किया था लेकिन उसके खिलाफ कुछ ज़्यादा सबूत नहीं मिले, तो ही कैन बी रिलीज, क्योंकि उसका रिलीज कैन बी कैंसिल ऑन. एंड स्टेट गवर्नमेंट में रिलीज एनी ऑफ द डिटेन्ड पर्सन विद विदाउट कंडीशंस बाय accepted by such permissions, but they can cancel it also. Now, if the government direct any bail or surety bond to be executed, then the person who has to surrender to the authority as per the order of release. Now, if that person fails to surrender for the imprisonment within 2 years, then a extra fine and extra imprisonment of 2 years can be imposed. Okay. Now, if a person is released, fails to fulfill the condition imposed upon him, then the bond will be forfeited and the surety will be liable to be. Okay, and no person can be released on the bail bond except upon section 12. So section 12 is a very important section that you have to remember. Okay, that is section 12. Section 13 के हिसाब से क्या याद रखना. Well, yes, section 13 के हिसाब से याद रखना कि कोई भी सूट, कोई भी लीगल प्रोसीडिंग will not be lying against the state government, against the central government, and no suit or legal proceedings or any other legal proceedings shall lie against any of the person acting as an officer in good faith. तो ये बातें कई बार बच्चे पूछते हैं, सर इलीगली डिटेन किया, बाद में मालूम पड़ा नहीं था. तो ये सेक्शन क्लियरली बोलता है कि आप सेंट्रल गवर्नमेंट, स्टेट गवर्नमेंट के खिलाफ कोई भी सूट किसी भी नेचर का फाइल नहीं कर सकते. ओके, फाइन. चलो, अब आते हैं पीएमएलए, प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट. उसके हिसाब से सेक्शन 5 अटैचमेंट ऑफ द प्रॉपर्टी है पीएमएलए का. तो वेरी इंपॉर्टेंट प्रोविजन है. एनी काइंड ऑफ डायरेक्टर, डेप्यूटी डायरेक्टर अगर किसी ऑफेंडर के खिलाफ प्रोविजनल अटैचमेंट लेती है तो दैट कैन बी गोइंग अप टू 180 डेज. दे हैव रीजन टू बिलीव से सामने वाले के पास मटेरियल पोजेशंस है, तब वो ऐसे अटैचमेंट ऑर्डर्स ले सकती है. ठीक है, तो दैट इज कॉल्ड अटैचमेंट ऑर्डर्स टू बी टेकन. दैट इज कॉल्ड अटैचमेंट ऑर्डर्स टू बी टेकन. ठीक है. नाउ एक बार अगर अटैचमेंट हो जाएगा तो रिपोर्ट जनरेट होगी तो मैजिस्ट्रेट कंसर्न में भेजी जाएगी या फिर ऑफिशियल कंप्लेंट फाइल हो जाएगी विद इन 30 डेज ऑफ द अटैचमेंट दैट हैज टू बी डन. अब इसमें मेंस फ्री इंपॉर्टेंट है क्या. वेल, कल्पेबल मेंटल स्टेट कैन बी मेड इंपॉर्टेंट. अगर कल्पेबल मेंटल स्टेट नहीं था तो क्या ऑफेंस था वो चीज़ बतानी बहुत ज़रूरी हो जाती है. ठीक है, so that's another aspect to be considered. Deputy director, and yes, the element of mens rea. ठीक है. yes, now offender. तो जो accused है, जो offender है, he can file an appeal to the high court against the attachment concern, and if the high court has given any kind of stay, तो जो period of stay है that will be excluded in the calculation of 180 days, and for the maximum 30 days can be added from the date of vacation of the order. ठीक है, याद रखना. So yes, the accused can be given, and further maximum 30 days can be added from the order. Clear? Then section 5 subsection 2 के हिसाब से क्या चीज़ें याद रखना. उसके हिसाब से याद यह रखना कि अगर कोई डायरेक्टर, डेप्यूटी डायरेक्टर जो है आफ्टर द अटैचमेंट फॉरवर्ड्स द कॉपी टू द एडजुडिकेटिंग कंसर्न, And section 5 subsection 3 के हिसाब से the term of attachment can be maximum 180 days के हिसाब से. However, if the investigation is completed earlier, then the term of attachment can be earlier than 180 days also. Section 5 subsection 4 के हिसाब से याद रखना, the provisional attachment order can be given by the director or deputy director concerned, and this will not prevent any person from immovable property to enjoy such immovable property. So you can use your immovable property accordingly. Section 5 subsection 5 के हिसाब से याद रखना, that is the director deputy director after the provisional attachment within 30 days files a complaint to the adjudicating authority that concern. Okay, then adjudicating authority section 6 के हिसाब से it shall consist of a chairperson, 2 members, and shall be appointed, and they shall hold the office for 5 years or 65 years of age के हिसाब से, and the CG may provide an authority for assisting them. Clear? Fine. Then staff for adjudicating section 7, that you can see, read it from the module. Section 8 क्या बोलता है? Well, section 8 बोलता है कि अगर adjudication चल रहा है तो adjudication के हिसाब से the director can file a complaint or application to the adjudicating authority, and the adjudicating authority will issue a show cause notice to the person involved to indicate the source of his income out of which such property was acquired and evidence to be laid down in this case as to why all the property should not be declared to be involved in money laundering. Okay. Now the proviso requires that notice has to be given to the person involved in money laundering, the person holding the property, okay, to the banks and who is the claimants or any kind of joint holders. That has to be done. Now 8.2 requires that the person to consider the reply of the notice and hear the case and take into account all the relevant materials in this regard. Here the adjudicating officers can pass in orders reflecting finding of all the properties, and if any person fails to who claims to the property to whom the notice is issued, then the opportunity of being heard is given not to be involved in money laundering. तो ये पार्ट भी एकदम क्लियर हो जाता है. क्लियर? अच्छे से सारी चीजें प्लीज 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 पढ़ के जाना. 8 सबसेक्शन 3 की रिक्वायरमेंट ऐसी है कि एडजुडिकेटिंग ऑफिसर जो है, adjudicating officer, when he decides that the property is involved in money laundering, so he will record in its order something in writing. What? That he confirms the attachment of the property, and if it was provisionally attached, okay, or he confirms the retention of the property if it is in the custody of the director, or retention of the seized property if it is frozen by the director, and this thing to continue for further 365 days from the date of investigation, or it has to continue till the pendency of the proceedings and becomes final if the order of confiscation is passed by the special court. Okay, then section 8 subsection 4 के हिसाब से याद रखना, on the confirmation of the attachment order, the director of the officer concerned, he will take into the possession his property, and if it is not practicable to take in the possession, then they will order the confiscation to be treated as order of confiscation. Okay, so that is section 8 subsection 4 के हिसाब से. Then section 8 subsection 5 and 6 के हिसाब से, when there is a conclusion of the trial in the special court and the property was found to be involved in money laundering, then it will be taken confiscated by the central government, and the property was found not involved in money laundering and no money laundering has taken place, then it will be released to the person who is entitled to receive the property, and then an application of the director or any of the person who is claiming the property can be made to the special court, and the special court can pass an order on the basis of the material brought before it. Okay, now in this case section 8 subsection 7 can be added. What is 8.7? Yeah, trial court cannot complete the trial because of the death of the accused, or that person is declared as a proclaimed offender, or any other reason. Then special court can pass orders based on the evidences which is produced before the special court. Okay, and 8 subsection 8 याद रखना. Yeah, 8 subsection 8 इसमें where the property is confiscated by the central government, and the special court can direct the central government to restore the property to the legitimate claimant, where the claimant has acted in good faith, they have suffered loss despite of the precautions, and they were not involved in any kind of money laundering, and was heard during the trial of the offense. So that can be decided in this case. Clear? तो ये कुछ सेक्शन से कुछ इंपॉर्टेंट पॉइंट से ये जरूर याद रखना. ये हो गया सेक्शन 8 का पार्ट. अब आते हैं उसके आगे. या सेक्शन 9. सेक्शन 9 टॉक्स अबाउट वेस्टिंग ऑफ प्रॉपर्टी. वेस्टिंग ऑफ प्रॉपर्टी में क्या क्या रखना? There is an order of confiscation of the property which has passed, and all the property will be confiscated by the central government. free from any encumbrances. During investigation, if the person under investigation, that is accused, that person creates any kind of encumbrance on the property or any kind of lease right, then the special court will direct that the encumbrance of the lease right against the property will be removed, and it will be free from all the encumbrances or lease rights in favor of the central government. And this order will be passed, will not be affecting the right of any party to file the suit for damages against any person who has created the encumbrance. So the person who has given the loan or person who has leased the assets, they can file the suits also. Okay. And Section 10 talks about any kind of management of properties under this Act. Section 11 talks about the powers that central government will assume while taking such property in their custody. Okay. So that is the basic thing. Basic 10, 11 is there. Yeah. 11 is yeah, that verification of identity of the person reporting. Well, reporting entities like banks, insurance companies, mutual fund, financial institutions, brokers, and reporting requirements. Kya? You have to check the Aadhaar card, you have to check the online verification, you have to either check the passports card or any kind of official documents. And summons, search and seizures के हिसाब से क्या क्या चीजें याद रखने का? Well, section 16 के हिसाब से 16 के हिसाब से हाँ, समन सर्च एंड सीजर्स के अंदर कुछ पार्ट्स आते हैं, दैट इज power to survey, power to search, arrest, power to search, summons, and power of detention. तो इसके हिसाब से सेक्शन 16 के हिसाब से क्या याद रखना? वेल 16 के हिसाब से याद रखना, पावर टू सर्वे का मतलब दी authority on the basis of the material that an offense of money laundering has been committed, and he may enter in any kind of place, inspect the records, take the veracity, and find the report. And the authority can even put the mark on the record or the inventory put or any kind of record in any state. Okay. Then 17 जो है 17 बोलता है the power of search and seizure and freezing of the records. Power of search and seizure. 17 में क्या रखना? That the director concerned, on the basis of the material in his possession, or he has reason to believe that something has been committed which constitute money laundering, or is in the possession of the proceeds of crime, or is in possession of related crime, then he will authorize an officer who is subordinate to him to conduct the search of any kind of building, or he has reason to believe that the search is required. Then that officer can break open any kind of doors, boxes, windows, almirah, anywhere. If the keys are not available, he can seize the records of properties wherever it is found. He can place the identification marks also. He can make the note of the inventory. He can examine on oath any person who is found during investigation. Okay, to know what is the actual fact of the case. That is section 17 की power. Section 18 की क्या power? The power to search persons. Power to search persons. Well, if the authority, on the basis of the material in their record, they find that any person has secreted his identity, his possession, his ownership, he's not revealing it, and they have reasons. So the director can search any person, they can seize any record, and whereby the authority searches a person, they can take him to the magistrate within 24 hours of the arrest, and he can be discharged by directing any kind of bail, bond, or surety. And the search can be conducted in the presence of at least 2 witnesses. And in case of women, we need another woman to conduct the search. And the authority will record all the statement of proceeds of crime if they have found it. Okay, so that is how to search a person. And section 19 talks about power of arrest. Yes, exactly, power of arrest. So if any kind of director or any kind of officer, on the basis of the material in their possession, that any person has been guilty of any kind of offense, then they can arrest such person and inform the grounds of arrest. And every person who has been arrested by the magistrate or by the metropolitan magistrate within 24 hours, okay, has to be informed by it. And section 50 goes with this power of summon on production. So 50 takes that the director or the adjudicating authority, he has or they have the same powers as the vested in the civil code for discovery, inspection, production of evidence, compelling a person to give evidence, receiving affidavits, issuing commissions, or any other aspect. Okay. Then we read this with section 2021. 2021 साथ में पढ़ सकते हैं, रिटेंशन ऑफ प्रॉपर्टी, रिटेंशन ऑफ रिकॉर्ड्स. प्रॉपर्टी की बात करें या रिकॉर्ड्स की बात करें, दैट इज एनी काइंड ऑफ प्रॉपर्टी और रिकॉर्ड्स कैन बी सीज इफ दे हैव रीजन टू बिलीव. that this property was required to be retained. Yeah, records has to be retained. And this property or records has to be retained for 3 months from the end of the month it has been seized. So on expiry of that period, they will return the property to that concerned person unless the adjudicating authority permits the retention for a longer period. Okay, and then 20 talks about presumptions on the basis of which this record can be seized. 23 talks about in presumptions of interconnected transactions. 24 talks about who has a burden of proof to prove that these kind of transactions are correct or not. Okay, so these are some of the things. So presumptions as to record, presumptions as to interconnected transactions, presumption as to records, and burden of proofs. And remember how it goes. So there is a director, additional director, deputy director. They file a complaint to the adjudicating authority. And here, if it is a crime, it goes to special court. And if it is appeal, it goes to appellate tribunal. Special court से appeal goes to high court, appellate tribunal से appeal goes to high court. Okay, इस चीज का ध्यान रखें. Then we see section 2526. 2526 basically ये बोलते हैं appellate tribunal के powers. The powers of the appellate tribunal will be as equal to smugglers and foreign exchange manipulators, Forfeiture of Property Act. Okay. Now, what are the procedure for filing appeals? Well, procedures for appeals कुछ ऐसा है. That is, appeal to the appellate tribunal can be filed by the concerned director, who is aggrieved by the decision of adjudicating officer, or by any of the reporting entity who are aggrieved by the decision of the director. The appeal has to be filed, time limit क्या within 45 days. Can there be condonation of delay? Yes, if there is a sufficient cause, condonation of delay can be allowed. Well, what about orders passing? Well, the appellate tribunal, after hearing the parties and considering the evidences, he can confirm, modify, or set aside any of the orders. The appellate tribunal will send the copies to the parties concerned adjudicating officer to the directors also. The time frame will be 6 months to file the appeal. Okay, so these are the basic things to remember for appeals. So appeals के लिए ये चीजें याद रखना. Procedures for appeals. Appeal has to be filed. Time limit. Condonation of delay. Passing of orders. Okay, time frame for disposing of. What are the procedures and powers of the appellate tribunal? Section 35 के हिसाब से. Well, the appellate tribunal जो रहता है is not bound by the provision of CPC, but they are guided by the principle of natural justice. They can delegate the power. The appellate tribunal have all the powers of the civil court. They can summon the attendance, require any person requiring any evidence, issue the commissions. They have all those powers. And the order which is made by the appellate tribunal is executable as a decree of a civil court. And the appellate tribunal can even transmit the order to the civil court of other jurisdiction if the party resides there, and it will be executed as a decree of the civil court, and all the proceedings shall be deemed to be a judicial proceeding. So that is the power and procedures of the appellate tribunal, section 35 के हिसाब से. Yeah, decision by majority. So if the members of the bench and they have difference of will, two members are there, they have difference of will, so they will make a reference to the chairperson concerned. The chairperson will conduct a hearing, and the decision will be passed by the opinions of the majority. Okay. Now, civil code, does they have jurisdiction in this case? So section 41 comes into picture. Civil code has no jurisdiction. So civil code has no jurisdiction and for all the matters that lie before the director, adjudicating authority, or appellate tribunal, and no injunction can be granted against the court or any kind of authority. Okay, what about appeals to high court? Section 42. Section 42 talks about appeals to high court. High court के अंदर high court within the jurisdiction of the aggrieved party, where the party ordinarily resides, उसको वाला high court, because appellate tribunal can be in Delhi also at times. So where the central government finds the is the aggrieved party himself, then they can appeal to the high court where the respondent resides, or where more than one of the respondent resides. Okay, so that's where the appeal can be filed. And yeah, the person aggrieved by the decision, they can file the appeal within 60 days of communication of the order. And condonation of delay, yes, if High Court is satisfied that the appellant is prevented by sufficient cause, they can pass the order for condonation of delay. Okay. Now, what about special courts? Let's see that special court. So special courts, they are court of sessions. Okay, they are court of sessions under section 43, and central government appoints special courts for money laundering matters. they can designate one or more civil courts for this designations, and special court will try the offense under the CRPCO. Okay, so these are the beginning part of special courts. Then that is section 43, who gives the authority. And yeah, 44, what is the jurisdiction of special court? Well, special court jurisdiction, firstly, offense which is punishable with money laundering under section 4 schedule offense के साथ. So it has to be tried by the special court of the area where the offense is committed. If the complaint is made by any kind of authority, the special court can take the cognizance without the accused being committed to trial, because they want to see whether the charges can be proved. After the conclusion of the trial, if no offense is proved, then the director authority has to submit a closure report for that. Now, if the court, which is not a special court, and they have taken the cognizance of the offense, then on application will transfer the case to the special court. And the special court, from the receipt of the case, they will start the case from the stage where it was committed. Special court, while trying the schedule offense or any of the offense of money laundering, will have the powers of CRPC also. Okay, so that is clear. And special court jurisdiction will be dealing with the offense of money laundering, but they can also deal with any other offense if that person has committed any other offense which is a criminal offense. So there can be trial jointly. But when the offense is only leading to money laundering under the schedule offense, other than schedule offense, then there cannot be joint trial. So that means if you have an offense of money laundering with a scheduled offense, then there can be joint trial. But if there is an offense which is not based on the schedule offense, then there will not be a joint trial. Okay, then the offense has to be treated separately in this case. And if the complaint has been filed and a further investigation has been brought into picture, and in that investigation the requirement of filing complaint comes into picture, then the complaint will be filed by the authority concerned, or whoever is putting the charges of money laundering against the party has to be done. So in simple words, the court cannot take the cognizance if proper complaint is not filed, may result into investigation, may not result into investigation. So the court has to see that the complaints have been properly filed in this case. Okay, so that is the jurisdiction of the special courts. The complainant has been filed. Okay, special courts के हिसाब से या explanation 1 ये भी deal किया, explanation 2 ये भी deal, ठीक है. ठीक है. So section 45 क्या बोलता है? Section 45 बोलता है nature of offense which is committed. The PMLA offenses are cognizable and non-bailable, and arrests by the police officer are without warrants. No bail will be granted unless the public prosecutor is given an opportunity of being heard. And where a public prosecutor opposes the application, then the court is satisfied that there are reasonable grounds that such person is not guilty of the offense and not likely to commit the offense, may be released on bail. And the special court may release the following person on bail: that is, person under the age of 16 years, a woman, or a sick person, or where the total offense of the accused or in the co-accused is less than ₹1 crore. And the special court cannot take the cognizance of the offense of money laundering unless a complaint in writing has been filed by the director concerned or by the officer appointed. And the police officer can investigate into the offense of money laundering only when specifically authorized by them. Section 46 क्या बोलता है? 46 बोलता है that the provisions of CRPC, including that of bail bonds, will be applicable to special court. And special court will be deemed to be the court of sessions, and representative of the government will be public prosecutor. Section 47 क्या बोलता है? High court will exercise its jurisdiction in the special court within the local limits. Okay, so that is section 46 and 47 के हिसाब से. ठीक है, and rest of these provisions you can study from the module as we have marked. Okay, तो ये पार्ट जरूर देख के जाना है, कॉर्पोरेट फ्रॉड्स के पार्ट्स को अच्छे से देखे जाना. तो विद दिस लेसन 6 का रिवीजन वाला पार्ट खत्म होता है, तो अच्छे से पढ़ के जाइएगा एग्जाम्स के हिसाब से. बाय.